Counterclaims, and cross-claims. A counterclaim may be asserted against an original counterclaimant. A cross-claim may also be filed against an original cross-claimant. That is Section 9. Section 9 is a new provision, but the concept of counterclaim is not new. As a matter of fact, it was already asked in the bar years ago. Example, C filed against you an action to collect a loan. You filed a counterclaim against her to recover a piece of land. Of course, she has to answer your counterclaim, but she will say, actually, you have been molesting me with your claim, when actually, you have no right over my land. So she files an injunction to stop you from molesting her. In other words, based on your counterclaim against her to recover your land, she will file a counterclaim to stop you from molesting her. In effect, there is counterclaim to a counterclaim. Reply. Under Section 10, all new matters alleged in the answer are deemed controverted. If the plaintiff wishes to interpose any claims arising out of the new matters so alleged, such claims shall be set forth in an amended or supplemental complaint. However, the plaintiff may file a reply only if the defending party attaches an actionable document to his or her answer. A reply is a pleading, the office or function of which is to deny or allege facts in denial or avoidance of new matters alleged in or relating to said actionable document. In the event of an actionable document attached to the reply, the defendant may file a rejoinder if the same is based solely on an actionable document. Illustration: plaintiff files a complaint against the defendant to collect an unpaid loan. D files his answer and raises a new matter, affirmative defense. According to the defendant, the obligation is already paid. Plaintiff said that you have paid the other loan. In other words, the plaintiff would like to deny or dispute the defendant's affirmative defense of payment. Can I file a pleading to dispute your defense? Yes, the pleading is called a reply. How do you classify a reply? It is a responsive pleading because it is the response of the plaintiff to the affirmative defense raised in the defendant's answer. So an answer is a response to the complaint, and the reply is a response to the answer. Assuming that you would like to answer my reply, what pleading would you file? None. That is the last pleading. So reply is considered as the last pleading. Effect of failure to file a reply. Suppose I filed a complaint, you filed an answer invoking payment. I failed to reply. What is the effect if the plaintiff fails to reply? Is he admitting the correctness of the defense? No. As a general rule, the failure to file a reply has no effect. Section 10 says that if a party does not file such reply, all the new matters alleged in the answer are deemed controverted, meaning all the affirmative defenses raised in the answers are automatically denied. So whether you file a reply or not, the defenses are deemed automatically disputed. The filing of a reply is optional. The plaintiff may file a reply only if the defending party attaches an actionable document to his or her reply, which falls under the exceptions. The other exception is to set up affirmative defenses in the counterclaim, Rosario versus Martinez, GR L4473. Note, only allegations of usury in a complaint to recover usurious interest are deemed admitted if not denied under oath. Hence, if the allegation of usury is contained in an answer, it is not necessary for the plaintiff to file a reply thereto in order to deny the allegation under oath. A reply should not be confused with the answer to a counterclaim, which is also filed by the plaintiff. Give the distinctions between answer to counterclaim and reply. 1. A reply is a response to the defense interposed by the defendant in his answer, while an answer to a counterclaim is a response to a cause of action by the defendant against the plaintiff. The filing of a reply is generally optional, whereas the filing of an answer to a counterclaim is generally mandatory under Rule 11 because if the plaintiff fails to file an answer to the counterclaim, he will be declared in default on the counterclaim. Third, fourth, etc. party complaint. A third or fourth, etc. party complaint is a claim that a defending party may, with leave of court, file against a person not a party to the action, called the third or fourth, etc. party defendant, for contribution, indemnity, subrogation, or any other relief in respect of his or her opponent's claim. The third or fourth, etc. party complaint shall be denied admission, and the court shall require the defendant to institute a separate action, where a. the third, fourth, etc. party defendant cannot be located within 30 calendar days from the grant of such leave. B. Matters extraneous to the issue in the principal case are raised, or C. The effect would be to introduce a new and separate controversy into the action. Third-party complaint is the procedure for bringing into a case a third person who is not a party to the case. It is a procedural device whereby a third party who is neither a party nor privy to the act or deed complained of by the plaintiff may be brought into the case with leave of court by the defendant who acts as third-party plaintiff to enforce against such third-party defendant a right for contribution, indemnity, subrogation, or any other relief in respect to the plaintiff's claim. The third-party complaint is actually independent of and separate and distinct from the plaintiff's complaint. Without this provision of the rules, it would have to be filed independently and separately from the original complaint by the defendant against the third party. The purpose of a third-party complaint is to enable a defending party to obtain contribution, indemnity, subrogation, or other relief from a person not a party to the action. Example, a plaintiff files a case against a defendant to collect a loan when there are two solidary debtors and one of them is compelled to pay everything, so that defendant will drag into the picture the co-debtor for contribution or indemnity. If the two of them were sued as defendants, all one has to do is to file a cross-claim against his co-defendant. But since only one is sued, the remedy is to avail of this section. Take note that filing a third-party complaint is not a matter of right. There must be leave of court, unlike counterclaim or cross-claim, where you do not need any motion or leave of court. There is a close relationship between a cross-claim and a third-party complaint, because a cross-claim must arise out of the subject matter of the main action. A third-party complaint must be also related to the main action. It cannot be a cause of action which has no relation to the main action. Example, the plaintiff files a case against the surety and the principal debtor, so both of them are defendants, and the surety seeks reimbursement for whatever amount he may be compelled to pay the plaintiff. What kind of pleading would he file against his co-defendant, the principal debtor? A cross-claim. But if the plaintiff files a case only against the surety, because anyway the principal debtor is not an indispensable party, and the surety would like to seek reimbursement from the person who benefited from the loan, he cannot file a cross-claim against anybody because he is the loan defendant. It is possible for him to just file an answer. If he loses and pays the plaintiff, then he will file another case against the principal debtor for reimbursement. But if he wants everything to be resolved in the same case, what kind of pleading will he file? He must resort to a third-party complaint and implead the principal debtor. The purpose of a third-party complaint is for the third-party plaintiff to ask the third-party defendant for contribution, indemnity, subrogation, or any other relief in respect to the opponent's claim. Contribution. Example, two debtors borrowed $100,000 from Jane, creditor, and they shared the money 50-50. when the debt fell due, the creditor filed a case against one of them. So one of them is being made to pay the 100,000, not only his share but also his co-solidary debtor. So if I am the one liable when actually my real liability is only 50,000, what will I do? I will file a third-party complaint against my co-debtor for contribution. Another example, if Andrew and Carlo are guilty of a quasi-delict and the injured party files an action for damages against Andrew only, Andrew may file a third-party complaint against Carlo for contribution, their liability being solidary under Article 2194 of the New Civil Code. Indemnification example, two people sign a promissory note in favor of the creditor, but actually the entire amount went to you and none for me. When the note fell due, I was the one sued, so I will file a third-party complaint against you for indemnity. You have to return to me every centavo that I will pay the creditor. Another, a surety sued for recovery of debt by the creditor may file a third-party complaint against the principal debtor for indemnity, and that is also under Article 2047 of the New Civil Code. Subrogation example. Oh, but before I continue, please hit that subscribe button. It is free to subscribe. You know, I have to ask this because I learned that some of us thought there is fee to subscribe. There is none. It's totally free. And the reason why I ask this is to keep me motivated and feel good about myself knowing I am doing something that matters. Thank you. I really appreciate it. Subrogation means that you step into the shoes of someone else. Your obligation is transferred to that someone else. Example, where a house is leased by a lessee and he subleased the property to a third person who is now occupying the property. In effect, the sublessee stepped into the shoes of the original lessee. If the property is damaged and the lessor sues the lessee for damages to his leased property, the lessee or sublessor can file a third-party complaint and have the sublessee for subrogation because actually you stepped into the shoes when you occupied the leased property. Articles 1651 and 1654 New Civil Code. For any other relief in respect to the opponent's claim, for example, when I buy the property of Mr. Cruz and after a while, here comes Mr. Reyes filing a case against me to claim ownership of the land, but I bought it from Mr. Cruz, who warranted that he is the real owner. So, I will now file a third-party complaint against Mr. Cruz to enforce his warranty against eviction, which is under Article 1548 of the New Civil Code. Take note that there is always a connection between the main complaint and the third-party complaint because the condition is contribution, indemnification, subrogation, and any other relief in respect to your opponent's claim. There is always a relation between the third-party complaint and the main complaint against you. And here is the bar question. Janice files a case against Nudge, sounds like Nadia, to recover an unpaid loan. Now, the reason is that Carlo also owes Nadia. Nadia says, I cannot pay you because there is a person who has also utang to me. What will I pay you? Depends on his payment to me. So Nadia filed a third-party complaint against Carlo. Is the third-party complaint proper? No. There is no connection between the main action and the third-party complaint. The loan of Nadia to Janice and the loan of Carlo to Nadia has no connection. Janice has nothing to do with the loan of Carlo to Nadia, not in respect to his opponent's claim. Bar question, how do you determine whether a third-party complaint is proper or improper? What are the tests to determine its propriety? The case of Capayas versus CFI. 77 Phil 181, which held that there are 4 possible tests to determine the propriety of a third-party complaint. In order for it to be allowed, it must pass one of them. That is the reason when you file it, you need the permission of the court to determine whether it is proper or not, and the original plaintiff may object to the propriety of the third-party complaint. There are the 4 tests. Anyone will do. 1. A third-party complaint is proper if it arises out of the same transaction on which plaintiff is based, or although arising out of another or different transaction is connected with the plaintiff's claim. Example, a creditor sued only one solidary debtor, so you can file a third-party complaint for contribution. Anyway, there is only one loan, and our liability arises out of the same promissory note. A third-party complaint is proper if the third party's complaint, although arising out of another transaction, is connected with the plaintiff's claim. Example, the car owner is sued for culpa aquiliana, for damages arising from vehicular collision, and he files a third-party complaint against the insurance company for indemnity based on the contract of insurance. So it is connected with plaintiff's claim, and that is precisely the purpose of my insurance coverage. Number 2, whether the third-party defendant would be liable to the original plaintiff or to the defendant for all or part of the plaintiff's claim against the original defendant. Although the third-party defendant's liability arises out of another transaction. Example, sublease. Roy leases property to Eric. Eric subleases it to Rudolph. If Roy's property is damaged, Roy will sue Eric, but Eric will also sue Rudolph. The sublessor has the right to file a third-party complaint against the sublessee for the damaged leased property, which is now occupied by the sublessee. The third-party defendant, Rudolph, would be liable to plaintiff's Roy's claim. Rudolph will be liable to Roy for Roy's claim against Eric, although the liability of Rudolph arises out of another transaction, which is the sublease contract. 3. Whether the third-party defendant may assert any defense which the third-party plaintiff has or may have against plaintiff's claim. Example, Tata is a registered owner of a car and then sold it to Philip. Philip is the actual owner. However, Philip did not register the sale to the Land Transportation Office. The registered owner is still Tata, although he is no longer the real owner. While Philip was driving that car, it bumped the car of Tanduay. Tanduay researched the owner of the car at LTO, and it came out that it's owned by Tata. Under the law, the registered owner is liable. So Philip filed against Tata. When Tata got the complaint, he said, I don't know what you're talking about. I sold that 2 years ago and I have no idea what happened. Well, obviously, Tata arrived at the conclusion that it was Philip who bumped Tanduay. So Tata filed a third-party complaint against Philip because he is the real owner now. So when Philip got the complaint, and he knows the story, in fact, he was the one driving, what he did was he assumed to be the defendant. So instead of Tata fighting Tanduay, Philip fought Tanduay directly, as if he is the real defendant. Then the third-party complaint must be proper. It must be related. Take note that there is a close similarity between a third-party complaint and a cross-claim, because a cross-claim must also be related to the same action. In the case of Samala versus Victor, 170 Scrap 453, facts. This case involves a vehicular accident. Philip, while riding on a passenger jeep owned by Tato, the jeep was bumped by a truck of Liwi, injuring Philip. Philip filed a case for damages arising from breach of contract against Tato. Tato filed a third-party complaint against Liwi. After the trial, the court found that Tato was not at fault. The fault is entirely against Liwi. So the action against Tato was dismissed, but the court held that Liwi be directly liable to Philip. It was questioned by Liwi. Liwi claims that it should be Tato who is liable to Philip because Philip did not sue him, Louis. So, why should I be liable when I was not the one sued by Philip? So, procedurally, I am liable to Tato. Tato is liable to Philip. Issue: can Louis, a third-party defendant, be held liable directly to Philip, the original plaintiff? Yes, that is possible in a third-party complaint. Normally, Louis is liable to Tato, but Louis can be made liable to Philip, or Louis can be made liable to both Philip and Tato because that is covered by the phrase or any other relief. So broad that it covers a direct liability of a third-party defendant to the original plaintiff. Issue number 2. How can the court award damages to Philip based on the theory of culpa aculiana when his complaint is based on culpa contractual? Can Louis be held liable for culpa contractual? Yes, that is also possible because the primary purpose of this rule is to avoid secretary of action and to dispose of in one litigation the entire subject matter arising from a particular set of facts. It is immaterial that the third-party plaintiff asserts a cause of action against the third-party defendant on a theory different from that asserted by the plaintiff against the defendant. It has likewise been held that a defendant in a contract action may join as third-party defendants those liable to him in tort for the plaintiff's claim against him or directly to the plaintiff. Another interesting case is the case of Schiffer versus Judge of RTC of Olongapo, 167 Squa 386. Note, this case, although refers to a third-party complaint which is related to criminal procedure. This is similar to the case of Javier, where the issue is there such a thing as a counterclaim in a criminal case where the offended party did not make a reservation? In Schiffer, is there such a thing as third-party complaint in a criminal case? Facts: Schiffer, while driving his car covered by TPL, bumped another car driven by T. T filed a criminal case against S for physical injuries arising from reckless imprudence. T did not make any reservation to file a separate civil action, so obviously the claim for civil liability is deemed instituted. Schiffer was covered by the insurance, so he filed a third-party complaint against the insurance company, and so far as the civil liability is concerned. The insurance company questioned the propriety of the third-party complaint in a criminal case, because according to the insurance company, the third-party complaint is entirely different from the criminal liability. Issue: whether or not the filing of a third-party complaint in a criminal case is procedurally correct. Held: yes, it is proper. There could be a third-party complaint in a criminal case because an offense causes two classes of injuries: the social and the personal injury. In this case, the civil aspect of the criminal case is deemed impliedly instituted in the criminal case. Schiffer may raise all defenses available to him insofar as the criminal and the civil aspects are concerned. Schiffer's claim for indemnity against the insurance company are also the claim by the victim in the criminal claim. Therefore, Schiffer's claim against the insurance company is related to the criminal case. So similar to Javier, that an accused may also file a compulsory counterclaim in a criminal case when there is no reservation. But in light of the ruling in the case of Caballero versus Cantos, the Schiffer ruling has to be set aside for the meantime because there is no such thing as third-party complaint in criminal cases now. In other words, forget it in the meantime. Also forget counterclaims in criminal cases, even if they're aroused out of the main action. This case refers to Javier on whether or not there is such a thing as compulsory counterclaim in criminal cases. Supreme Court said, no. If we will allow it in criminal cases, it will only complicate and confuse the case. The attention might be divested to counterclaims or cross-claims or third-party complaints, etc. Held: the trial court should confine itself to the criminal aspects and the possible civil liability of the accused arising out of the crime. The counterclaim and cross-claim or third-party complaint, if any, should be set aside or refused cognizance without prejudice to their filing in separate proceeding at the proper time. So, did we just waste our time? But these old cases are interesting. Another old case is the Republic versus Central Surety Company, 25 SCRA 641. Facts: Hannah filed a case against Rena for a liability amounting to $350,000, so it was filed in RTC. Rena filed a third-party complaint against Concon Insurance Company for indemnity insurance, but the maximum insurance is only $50,000. The insurance company moved to dismiss on the ground that the court has no jurisdiction because third-party complaint is only $50,000, which is supposed to be within the competence of the MTC. Issue: is the insurance company correct? Held: no, the insurance company is wrong. The third-party complaint is only incidental. The third-party complaint need not be within the jurisdiction of the RTC, where the principal action is pending, because the third-party complaint is really a continuation and an ancillary to the principal action. If the court acquires jurisdiction over the main action, automatically it acquires jurisdiction over the third-party complaint, which is mainly a continuation of the principal action. Now, the same situation happened in another case, the case of Eastern Assurance versus CUI, 105 SCRA 642. The facts: Carol is a resident of Davao City. Cathy is a resident of Cebu City. Carol filed a case before the RTC of Davao against Cathy. Cathy files a third-party complaint against Joy, a resident of Manila. Is the venue proper? Held: the venue is proper because the venue of the main action is proper. So automatically, third-party complaint is also proper. The third party has to yield to the jurisdiction and venue of the main action. Now, of course, if there's such a thing as third-party complaint, there is also a fourth, fifth, sixth, or seventh complaint. That is possible, but everything is with respect to his opponent's claim. Example: A files a complaint against B. B files a third-party complaint against C. C files a fourth-party complaint against D. And D files a fifth-party complaint against E. A's car was bumped by B, but B contended that the reason that he bumped A's car was because he was bumped by C. And the same goes to C, D, and E. B then files a third-party complaint against C. C files a fourth-party complaint against D. D files a fifth-party complaint against C. They will throw the liability to the one who did it. That is a good hypothetical example of how a fourth, fifth, sixth party complaint can come into play. Rule on venue and jurisdiction inapplicable. Jurisdiction over the third-party complaint is but a continuation of the main action and is a procedural device to avoid multiplicity of suits. Because of its nature, the prescription on jurisdiction and venue applicable to ordinary suits may not apply. Eastern Assurance versus CUI or CUI, 105 SCRA 622. What are the grounds for denial of third-party complaint? A. When allowance would delay resolution of the original case or when the third-party defendant could not be located. And B. When extraneous matters to issue of possession would unnecessarily clutter a case of forcible entry. Del Rosario versus Jimenez, 8 SCRA 549. Summons on third, fourth, etc. party defendant must be served for the court to acquire jurisdiction over his persons, since he is not an original party. A third-party complaint is not proper in an action for declaratory relief. Where the trial court has jurisdiction over the main case, it also has jurisdiction over the third-party complaint, regardless of the amount involved, as a third-party complaint is merely auxiliary and a continuation of the main action. Republic versus Central Surety and Insurance, GR 27802. Section 12. Bringing new parties. When the presence of parties other than those to the original action is required for the granting of complete relief and the determination of a counterclaim or cross-claim, the court shall order them to be brought in as defendants, if jurisdiction over them can be obtained. Distinguished from a third-party complaint. A third-party complaint is proper when not one of the third-party defendant therein is a party to the main action. If one or more of the defendants in a counterclaim or cross-claim is already a party to the action, then the other necessary parties may be brought in under this section. And the best example of this section is the case of Sapugay versus CA 183 SCRA 464. Facts. Mobile Philippines filed a case against Sapugay, its gasoline dealer. Sapugay filed an answer and interposed a counterclaim for damages against Mobile and included Cardenas, the manager of Mobile, who is not a plaintiff. Issue whether or not the inclusion of Cardenas in the counterclaim is proper, where he is not a plaintiff in the Mobile case. Held, the inclusion of Cardenas is proper. The general rule that the defendant cannot by a counterclaim bring into the action any claim against persons other than the plaintiff admits of an exception under this provision, section 12. Meaning, if it is necessary to include a third person in a counterclaim or cross-claim, the court can order him to be brought in as defendant. In effect, the bringing of Cardenas in the case is sanctioned by these rules. The case of Sapugay should not be confused with the case of Chavez versus Sandiganbayan 198 SCRA 282. Facts. Petitioner Francisco Chavez, former Solicitor General, represented the government for PCGG. The case arose out of PCGG's cases wherein Enrile was sued for accumulation of his ill-gotten wealth and really filed an answer to the complaint, and really contends that the case is harassment suit whose mastermind was the sole gem himself, and really files a counterclaim against Chavez. Well, Enrile's lawyer may be well aware of the Sapugay case, where the one sued is the lawyer. Chavez questioned such counterclaim, contending that he was not a plaintiff. Sandiganbayan denied such contention. Held, the inclusion of plaintiff's lawyer is improper. To allow a counterclaim against a lawyer who files a complaint for his client, who is merely their representative in court and not a plaintiff or complainant in the case, would lead to mischievous consequences. A lawyer owes his client entire devotion to his genuine interest, warm zeal in the maintenance and defense of his rights, and the exertion of his utmost learning and ability. A lawyer cannot properly attend to his duties towards his client if in the same case he is kept busy defending himself. Is the Supreme Court suggesting that a lawyer who sued in a harassment case get away with it? Does that mean to say that the lawyer is immune from suit? No. The Supreme Court does not say a lawyer enjoys a special immunity from damage suits. However, when he acts in the name of the client, he should not be sued in a counterclaim in the very same case where he has filed only as a counsel and not as a party. Only claims for alleged damages or other causes of action should be filed in a separate case. Thus, if you feel that the lawyer is acting maliciously, you file a complaint, but in a separate case. That is why the case of Sapugay should not be confused with Chavez. Answer to third, fourth, etc. party complaint. A third, fourth, etc. party defendant may allege in his or her answer his or her defenses, counterclaims, or cross-claims, including such defenses that the third, fourth, etc. party plaintiff may have against the original plaintiff's claim. In proper cases, he or she may also assert a counterclaim against the original plaintiff in respect of the latter's claim against the third-party plaintiff. That is section 13. Illustration: A files a case against B. B files a third-party complaint against C. That is C. So A versus B, B versus C. Normally, B will defend himself against the complaint of A, and C will defend himself in the complaint of B. That is supposed to be the pattern. C does not file a direct claim against A, but the law allows C in defending himself to answer the claim of A. The law allows him to file a direct counterclaim against A. If C has the right to frontally meet the action filed by A, meaning C filed A directly, if C has the right to assert any defense which B has against A, and even for C to litigate against A, then it must be a proper third-party complaint. That has happened several times. Example: B owns a car which was already sold to C. The trouble is that B never registered the transaction. On the record, B is still the registered owner. Then C, while driving the car, meets an accident and injured A. When A looked at the record, the owner is B, so A filed a case against B. So B will file a third-party complaint against the real owner, C. Now C can frontally meet the complaint filed by A. That is the best example where you have the right against the original plaintiff, or even assert a counterclaim against him. As a matter of fact, that last test is now incorporated as a new provision under Section 13. In the case of Singapore Airline versus CA 243-143. Facts. Aying filed a case against Bugoy. Bugoy filed a third-party complaint against Kyle, who wants to frontally meet the main complaint filed by Aying. Held, if that is your purpose, you have to file two answers. You file an answer to the third-party complaint, and you file a second answer to the main complaint filed by Aying. A third-party complaint involves an action separate and distinct from, although related to, the main complaint. A third-party defendant who feels aggrieved by some allegations in the main complaint should, aside from answering the third-party complaint, also answer the main complaint. Normally, Kyle answers the third-party complaint of Bugoy and does not answer to the complaint of Aying. But according to Singapore case, if Kyle feels aggrieved by the allegations of Aying, he should also answer the main complaint of Aying. Practically, he shall answer the third-party complaint and the main complaint. So that concluded our types of pleading. And before you go to my next audio on parts of a pleading, please hit that appreciation button in acknowledgement to my hard work, spelled subscribe. Thank you.